Item J, reports to the IVGID Board of Trustees. District General Counsel, Mr. Guanasso.
Yes, thank you, Madam Chair. Over the last several weeks, we've received several inquiries regarding 87 unbuildable tax delinquent properties acquired from Washoe County in October of 2012, and the subsequent sale of 3 of those properties during the period of 2012 to 2015. Those inquiries, as reflected in the materials we've provided to you, came from members of the community, including Mr. Katz and Mr. Wright. We also received an inquiry from Washoe County Commissioner Marcia Burke-Bigler. And then most recently, within the last week, we received inquiry from Reno Gazette-Journal reporter Anjanette Damon, who had contacted the district with questions about the acquisition and sale of the subject properties. The inquiries from Mr. Katz and Mr. Wright and Commissioner Burke-Bigler and the written responses thereto have been provided in this board packet for your review. Ms. Damon has spoken by phone to General Manager Pinkerton, Director of Finance Jerry Ike, and myself. But because this has gotten so much attention, or renewed attention, I should say, because the renewed interest in these 87 unbuildable tax delinquent properties that were acquired in 2012, I've prepared this report to the board. And just by way of background, in 2012, IVGID acquired 87 non-buildable tax delinquent properties from Washoe County in accordance with NRS 361.603. These properties were originally a part of the Bitterbrush subdivision, which is a kind of a condominium complex. As explained in the July 31st, 2012 board memorandum, the primary interest in these parcels was that 69 of the parcels were carried on the recreation roll, and as such impacted IVGID's annual budget. Now, although the stated public purpose for acquiring the subject properties was listed as, quote, open space, close quote, this term is somewhat of a misnomer given the fact that these properties really represent a property interest in a condominium development where there is shared ownership interest in the land and in the buildings. The subject properties are considered unbuildable and lack any value other than the recreational and beach privileges attached to them. By acquiring these properties, IVGID was put in a position to accomplish 3 important objectives. Number 1, they were put in a position to recover delinquent fees from a failure of those property owners to pay rec and beach facility fees. Number 2, it allowed for an opportunity for those properties to be reinstated back onto the recreational roll with property owners who would pay the recreation and beach facility fees. And number 3, it allowed IVGID to retain interest in property within its jurisdiction that has no other market value other than the fact that the property retains recreational and beach privileges. Now, NRS 318.160 gives the board authority to acquire, dispose of, and encumber property. In this regard, that statute provides that the board shall have the power to acquire, dispose of, and encumber real and personal property, and any interest therein, including leases, easements, and revenues derived from the operation thereof. The constitutional and inherent powers of the legislature are hereby delegated to the board for the acquisition, disposal, and encumbrance of property, but the board shall in no case receive title of property already devoted to public purpose or use except when consent of the owners of such property and except upon approval of a majority of the board. Now, with regard to the acquisition of the subject properties, staff was given specific direction from the board on August 8, 2012 to acquire the subject properties from the county. After the properties were acquired, IVGID sold 3 of those properties, and I'll just list them by APN number. They're also provided in the packet of materials. but APN number 126294-28 is located at 400 Fairview Boulevard, and legal description of that property is at page 384 of your board packet. A purchase contract was entered into on January 3rd of 2014. The sale of that property closed on March 31st of 2014. The sale price was $14,095, and this sale price was based on back recreation and beach facility fees owed to IVGID at the time of sale, consistent with Board Policy 16.1. No HOA dues are owed on, or were owed on those properties. That is, whatever the HOA would otherwise assess to a property owner, those fees were waived because of the nature of the property interest being sold. And no back taxes were owed to the county, because when the county transferred those parcels to IVGID, they waived their right to collect taxes on those parcels. As a practical matter, the reason why the county might do something like that is because as back taxes accrue over time, it becomes a deterrent from the private sector of acquiring those properties. And so when you're dealing with unbuildable pieces of property that have no value, and there's a high tax lien associated with those properties, likelihood of being able to get rid of those delinquent assets is slim to none. But that being said, the second subject property that was sold was under APN 126294-29. Purchase contract was entered into on June 27th of 2014. That property closed, the sale of that property closed on July 18th of 2014. The sale price for that was $14,095. Again, the price was based on back recreation and beach facility fees owed to IVGID at the time of the sale, consistent with Policy 16.1. Again, no HOA dues owed and no back taxes owed to the county. Finally, APN 126294-18, again at 400 Fairview Boulevard. The legal description for that property is at page 408 of the board packet. A purchase contract was entered into on November 20th of 2015. That sale closed on December 10th of 2015. The sale price for that property was $17,152.55. The sale price was, again, based on back recreation and beach facility fees owed to IVGID at the time of sale, consistent with Policy 16.1. Now, with regard to the foregoing sales, staff exercised its authority to consummate contracts valued under $50,000 under IVGID policy 3.1.0 sub F. And just to review that policy with you, for those of you that don't have that up in front of you, that policy provides contracts other than those covered by NRS Revised Statute 332.115 and which are not subject to the advertising thresholds of NRS 332 and or 338 may be authorized, approved, and executed by the general manager of the district or designee unless otherwise ordered by the Board of Trustees. Contracts covered by NRS 332.115 may be authorized, approved, and executed by the general manager or his designee if it is for amount less than the advertising threshold of NRS 332. Contracts over the threshold of NRS 322, or 322, 115 must be approved by the Board of Trustees.
Jason?
Yeah.
I have a question.
Mm-hmm.
I spoke with Marcia today because I'd heard, this activity had taken place and lots of concern in the community. And she said that, of according to the NRS statutes, any public lands, whatever you want to call them, via contract or whatever, have to be approved by the board and have to be put out to auction because they're public lands, and these were public lands, and that was not the case. And so I guess the county commission met in private yesterday, or whenever they had their meeting, and they're very concerned with how this all took place. And she said that there is going to be a letter forthcoming to the district, probably within the next 5 to 7 days, from the district attorney, who is very concerned that the sale of public lands took place without the then board approval, meaning in 2015 it would have been Kendra and I and the now 3 non-existent trustees who were on that board, but we had we weren't even aware that had taken place. And so because these lands, the 3 properties were sold by an unelected official without board approval, the county is very concerned, as is Tammy Davis from the tax office. And they will be putting this all out and again sending a letter to the district. And the concern that I have is that, luckily this all stopped before we could get any kind of clarity. And I think that it's unfortunate because I think that possibly one or several of our employees were given erroneous information. This is all prior to you and your firm coming on. But I think that they were perhaps misled to potentially and inadvertently break the law. And the concerns that I have is I don't want to see anybody in our district, specifically Mr. Ike or anybody else, be implicated, because this is a very serious situation. The county is very, very angry, and they are going to pursue this. And so I just wanted to disclose that because I just literally heard that today from Marcia at about, I don't know, a half hour before I came into the meeting. And so I'm concerned that the interpretation of the specifics of NRS on how public property is dispensed with by a public entity, that if we haven't been compliant, then I'm sure we'll be asked to become compliant. And I just am really concerned that we inadvertently, as a district, may be culpable for something that we were unaware of.
Appreciate the information and the concern. I certainly look forward to whatever correspondence the district attorney would send with points and authorities that would suggest that IVGID or any of its employees would have violated the law. If the points and authorities, though, that are cited are the same points and authorities that Ms. Burke-Bigler provided in her email, which we've provided to you in the packet, I will just tell you that those points and authorities don't apply to general improvement districts. They specifically apply to counties. And so, but if there are other points and authorities, I'd be interested in looking at those. I would note, I think, just to refresh your memory, that these properties and the sale of the properties related thereto were actually a matter of common knowledge for particularly for you, Trustee Calicrate, as well as for Trustee Wong. I've got an email dated October 7th of 2014 where Trustee Wong, at the time who was a candidate, had asked questions about these parcels. And in response to those questions, and you were copied on the email as well as Robert Ulmer, Sheila Lejean, Jim Smith, Jim Smith, Jim Hammerl, Bill Devine. You were all provided answers, and really that it wasn't just the acquisition of the property; it was the fact of the sale of the property, and so this hasn't been something that's been a secret. And in fact, this has also come up in the CAFRs each of the years that you've reviewed a CAFR, and it's been a part of a board budget discussion. So this hasn't been something that we have not been aware of. But let me say this. I had this conversation with Trustee Dent the other day. after the conclusion of the sale in 2015, and keep in mind this is my firm's first year with the district, staff had a conversation with legal counsel about these sales, and we determined to put a moratorium on the sales of the previously referenced unbuildable lots until such time as a policy could be drafted and presented to the Board of Trustees regarding a process and procedure for receiving offers and approving contracts for the sale of the subject properties. So in this regard, staff and legal counsel had agreed to include the drafting of the policy as a part of the district's effort to update and qualify its policies, practices, and procedures in the form of the IVGID code. And I think it's important to note that since that time, the end of 2015 to present, there have been no further sales. And I think an important reason for that is while I stand behind the legal authority to dispose of the properties in the way that they were, that is under 318 and under the delegated authority you've given to your staff to enter into these sort of contracts, I stand behind that legal authority. The question that remains is how are individuals select, or how do we know that individuals are interested in pieces of property, and how do we come up with a sale price? And so what's the process that we go through to ultimately consummate a sale of the subject properties? Because the goal to recover lost fees is a part of your fiduciary responsibility and an important objective. And making those properties productive in terms of producing a rec fee going forward is also part of your fiduciary responsibility. But the real question is, how do we go about making known that these properties could be available for purchase, and how do we go about selecting who gets to purchase them? And that's a policy discussion that has to happen at the board level. It shouldn't happen without some discussion on the board's part and some specific direction. And that was our position then. And Mr. Ike was very sensitive to that issue. In fact, brought that to our attention as legal counsel and wanted our feedback, and in fact asked us to draft a policy. And really the only reason why we don't have a policy is we had a number of other issues occurring, but codifying all of our policies, practices, and procedures, and this being one of probably a couple of dozen that really need to be updated and codified into a code. We just haven't got there yet. I'm anticipating in January, as is reflected on the long-range calendar, January, February, we'll have the first iteration of the code for you all to review, wherein I'll have some proposed language for this policy. But certainly, if the board wants to expedite this or make this a higher priority than some of the other things we're working on, the board certainly has the discretion to get this on the agenda and offer that direction at a later date. But I just want to emphasize that the transactions as they've occurred in the past are supported by the NRS and the delegated authority that this board has given to your staff. And but that being said, there definitely is need for a policy. And I want to emphasize there hasn't been any sales of any other property since 2015. And so I think that speaks volumes with regard to the intent, of your staff in terms of trying to get a policy before you, and is, should mitigate any concerns from those who would review what was done and why. And so if there aren't any further questions, that would conclude my report.
Well, I remember having a conversation when I was running during the election, and I remember the conversation being consistent with what you just reported, that we would, at some point, there needs to be board direction and a policy set. So I guess how, that was 2014, and then there's a transaction in 2015. So if the conversation in 2014 was, we need to identify a policy and we're not going to sell any more parcels, then I actually do want to understand what happened with that parcel that was sold in 2015, because that is definitely inconsistent with the timeline that I remember and what was communicated to me. Granted, I was not on the board at the time when I had the original conversation. I think I'd want to understand that to start, and then I think, yes, as we get into the codification, we definitely do need to develop some guidelines, policies, because, you know, quite frankly, just thinking about our neighbors in Crystal Bay, there are way more neighbors in Crystal Bay than there are parcels available. So then, you know, and I think all of us would agree that if we're going to sell them, we want it to stay in our community. I'm making that assumption, but if I were to run through a thought process, I would want them to stay in our community, being Incline Village and Crystal Bay. And, you know, I think we would have to start there. But, yeah, I think that first I want to understand what happened between 2014 and 2015, because there seems to be an inconsistency there.
Well, I can just clarify it as I look at the old information. We really hadn't discussed. All we did at that point in time was say that we had these potential assets and they may be sold in the future. We really hadn't talked yet about moratorium or stopping or policy or anything like that. That kind of evolved during 2015 when we got new legal counsel.
Okay.
Yeah, so if you recall, we started as your firm in January. The two of those parcels had been sold before we were involved, and then this third parcel came to our attention. I believe it was in October of 2015, and I looked at what had happened previously and previous board counsel's advice, and I said, go ahead and consummate that sale consistent with what you had done with the previous two parcels, but after that, no further sale of any of these parcels until we draft a board policy and present it to the board for review and approval.
Yeah, I remember certainly after I was appointed in December of 2015, I guess it was, in early 2016, I became aware of it, and at that point in time, it had certainly been, it wasn't going to happen until the board came up with some rationale to handle the process, and who and what and how much.
Yeah, my only regret is just not having a policy to you sooner. And again, you know, this issue isn't an issue that's a new issue. It's something that's been around for a while that we're all been well aware of. You know, the need for the policy hasn't been lost on anybody, and that's why there hasn't been any sale of these unbuildable parcels, because we just have determined until we have a policy in place, there's not going to be any sort of sale like that. So.
And just to note, we did have our 16.1 policy for unbuildables, but we realized this one needed to be expanded beyond that. That's
true. That's true. And it really, 16.1 really had to do with getting those parcels back onto the rec rolls, if I recall correctly.
So we'll add this onto our list of things that we need to do. Any other questions?
In the event that we do get a letter from Washoe County, I will be sure to circulate that and then provide an appropriate response. Thank you.
Okay.
I just want to confirm, certainly what I'm hearing from you is that staff operated within the policies and that we had and the regulations from the state, and certainly it appears acted in good faith on those, but with
I don't know about increasing, but concern that they brought to you as the council at the time. So I understand that, and I think we definitely got to understand that as a new board members. Moving forward, I want to be assured that, here we're dealing with, particularly with real property, that does any action needed by the board to ensure that there is a moratorium on selling any real property without board approval?
We certainly couldn't take that action based on my report right now, but my recommendation would be to address this issue in the form of a policy that would be reflected in the IVGID code. I think that's the right place to put it, and I think it would, right now there's no sense of urgency because these properties aren't being sold until there's a policy in place, and we're in the process of drafting that policy and including it in the code that you all get to review and comment upon.
Any other questions for Mr. Guanasso? Okay, that will close item J.